Good morning, everyone, and welcome to this webinar in which we're going to focus on the forthcoming employment reforms that relate to both family leave and flexible working. And before we get going, we would like to introduce ourselves. I'm Victoria Templeton, the HR Knowledge Manager here at HR Solutions, and I'm joined today by Sue Watson. Sue's our Operations Director, and together we're going to guide you through this topic. And because we've got so many of you with us today, we've placed you all on mute. However, as always, we do want to get your involvement in today's webinar, and there's a couple of ways in which we can do that. So first of all, we'll be inviting you to ask us your questions, and we aim to answer as many as we can in the time that we have at the end. And then on the screen now, what you'll see is the question panel. So simply add your question, submit it, and then, as I said, we'll aim to read out as many as we can at the end. And another way of engaging with you all, we like to make our webinars interesting with understanding what you're all thinking about the topic, and we do this by using polls. So these not only help steer the webinar, but it allows us to share how the topic's being managed in other workplaces. And actually, it can be a really good way to understand what other organisations are doing, as I said, with the particular topic that we're talking about. So when you see this slide, we're going to run a poll. They are confidential. We only publish the results to the questions. And as always, we like to welcome as many of you today sharing your insights with us. As far as the agenda goes, so there's a lot to talk about in terms of these reforms under the Employment Rights Bill. The bill is set to bring further developments to UK family leave entitlements and in the management of flexible working requests. So I'm going to start off talking you through what these proposed reforms are. We'll then consider how your business can prepare for these changes, and by considering the potential implications of the reforms, as well as the practical steps that you can take. And then I'll finish off giving you an indication of when you can expect the changes to come into force using the latest government information. And then we'll be taking your questions at the end. So as I said, please do submit your questions as we go through, and we'll answer as many as we can at the end. Just a couple of practical points. You will all receive a copy of the slides from the webinar today. So that will be circulated along with a recording of the session. And we also have lots of information available that's relevant to today's topic. So I'm going to be covering that towards the end, just prior to the Q&A. So look out for that. So let's start with 3 quick polls. So if I could ask you to open the first one, and that's just really so we can get to understand the organisations that you're all from. Is the poll okay, Sue?
Yeah, that's running. Yeah.
Is it the right poll?
That's the first one I've loaded.
Okay.
Yeah, that one's finished. I'll close that one and I will share the results. There we go. So 94% do monitor.
Okay.
Okay, I think, yeah, it looks like I think the poll's got slightly out of order, hasn't it?
Yeah.
Let me just close that one. Let me see if I can find the correct one.
So whether they're micro, small, medium, large organisations?
Yeah, actually, I think the polls don't seem to have loaded correctly. Really sorry. Oh
no.
Yeah. Yeah, sorry everybody, we're having a technical issue with the polls. Okay, back to you. We'll continue.
Okay, thank you, Sue. Sorry about that. I don't know what's happened there with the system. So let's move on in terms of understanding what's changing with these 2 areas in employment law. So the first one is relating to parental leave, and the current entitlement is that as an employee, they have the right to take unpaid parental leave if they've been in continuous employment for 1 year, and they expect or have parental responsibility for a child under the age of 18 years. So the entitlement is for each child, with the maximum of 4 weeks leave taken in each year. So what the Employment Rights Bill is going to do is actually remove that 1-year qualifying service criteria. So actually everybody in your organisation who meets the criteria will be able to take a period of parental leave. And when we look at paternity leave, this is kind of similar. So currently an employee needs to have a minimum of 26 weeks service at the 15th week before the expected week of childbirth or at the matching week when adopting. And at the moment, an employee actually loses their entitlement to paternity leave and pay if they take it after a period of shared parental leave. But what's going to happen through this, the bill, is actually they're going to remove the qualifying service by making it a day one entitlement. So as you can see, we already have many family leave entitlements at day one, so it's all bringing it in line. But they're also going to try and rectify this aspect of the paternity legislation by allowing employees to take it either before or after a shared parental leave. So they're going to rectify that issue there. In terms of bereavement leave, then there will be some changes. So at present, in a deeply tragic event, an employee suffers a loss of a child under the age of 18, or even somebody that suffers a stillbirth from 24 weeks of pregnancy. Currently, they're entitled to a statutory right of 2 weeks parental bereavement leave. Now, this entitlement to leave is a day one right, although to be eligible for pay, the employee must have 26 weeks continuous service. And what the Employment Rights Bill is going to do in this is actually broaden this piece of legislation so that everybody has a statutory entitlement to bereavement leave. So actually the parental word in the title will be removed, and it's going to be extended so that all employees, will have a statutory entitlement to bereavement leave, not just those that lose a child or suffers a stillbirth. And whilst I guess the thing to note is that whilst in the event of the death of a child or stillbirth, as we know already, that's paid, for all other relationships and circumstances, the bereavement leave is expected to be unpaid. So we do need to have more details in the form of regulations to understand the practical application of it, to understand how long people can have off and things like that. But we do know that it's unlikely to be paid for all other employees. So we're also going to see some developments in the area of dismissals. If you remember last year, the law changed around extending the law regarding protection against dismissal in a redundancy situation. And what that meant was employees that are pregnant or on a period of family leave, so adoption, maternity, neonatal, shared parental leave, and those returning from those family leaves, then they were given priority for redeployment opportunities if their role was to be made redundant. Now that special rule means that if they were to be dismissed due to redundancy during any of those time periods without having been offered suitable alternative employment or being considered, then it would be automatically an unfair dismissal. What the bill is going to do now is broaden that so that the legal protection will be extended to cover all dismissals. So as you know, the potential fair reasons for dismissals can be capability, conduct, some other substantial reason, etc. And they're going to apply that principle that already applies to redundancy dismissals to all other types of dismissals. Again, we need the details through regulations being drafted so that we can understand more about what the obligations are going to be and how they are to operate in practice. But just to give you some examples of some potential rules, because the current version of the bill, having gone through a period of debate and consultations, and we've seen many amendments being submitted and raised. So rules could include things like setting out what notices are to be given by employer and employee, the evidence to be produced, and other procedures that are to be followed by both parties in the lead up to obviously there being any form of potentially fair dismissal. There's also talk about determining what consequences there'll be for the employer where there's been a failure to give notices, producing evidence, or even complying with other procedural requirements. And there's talk about setting rules to adjust the rules for calculating a week's pay for awards at tribunal. So for employees who are absent, as I said, or have been on a period of family leave or on return, these are kind of rules that we can perhaps look to see getting implemented. But as I said, we need regulations to give us a detail about how we should manage those kind of procedures. Okay, there we go. So can I just check, Sue, is there a problem with these subsequent polls as well? Let me just check.
There is at the moment. Hopefully we can have a
Okay.
couple in a second. Okay, all right.
Yeah, lovely.
Okay.
Let me just move on for a moment. So the other aspect is flexible working, and that's perhaps the most significant area. I think because it's central to the employment relationship across all industries, largely due to advancements in technology that have empowered employers to offer more flexible arrangements in recent years. The pandemic obviously further accelerated this shift, leading to a substantial increase in flexible working options. So we've got more available to us. And I guess with all the press that will come with the implementation of the reforms in this area, there's going to be a lot of talk. And so we may get an influx of flexible working requests. So in terms of the current rules, I'm sure you're all familiar with what the law is at present in regards to when you refuse a flexible working request, in that it has to be for a specific reason. It's got to meet one of the statutory reasons that are specifically set out in the legislation. And that obviously as an employer, you're required to handle requests reasonably. And we've got the code of practice to support us in doing that. What we're going to see come in force is rather than the requirement for the employee to handle the request reasonably, it's going to become a legal requirement that the refusal must be reasonable. And secondly, when rejecting a request, not only will the reason have to fall in line with the usual statutory decline reasons, which aren't expected to change, by the way, but that the employer must explain why it considers the refusal to be a reasonable one. And it might not necessarily seem like a big change, but I think it actually will be, and it's going to make it even more important to have really robust paperwork when you're managing your flexible working applications. It's going to need more thorough examination of the business context, because ultimately it's that goes on to form your rationale for why you're refusing or accepting. The difficulty is we don't know what reasonable is, and you'll know from other areas of employment law, reasonable is never defined. It's really hard to do so. And like with this, what's a reasonable reason? Was your decline reason reasonable? We don't have that detail, and it's unlikely we will get a specific tick list. We could have information in the form of an ACAS code. We already have an existing one, so that's likely to get, well, it will be updated. And it could, from there, provide with guidance. But what we know as a concept, reasonableness is an objective test based on what a reasonable employer would do in similar circumstances. And so it means that what may be reasonable to one employer may not be to another. So clearly, if you've got an organisation that employs 10 individuals and then another one that is somewhere that, I don't know, employs 300, clearly those circumstances in the business context are completely different. So what might be reasonable to the larger one won't be to the smaller organisation. And so, as I said, in other areas of employment law, reasonableness isn't defined, and we have to look to previous case rulings to give us that guidance, and as well as public guidance information through things such as the ACAS Code of Practice. They're the things that can help us decide taking a reasonable step. And things like, just there's an element of, if it was you, how would you want to be treated if it was your application? There's that element of reasonableness as well. So as I said, they're going to update the ACAS Code of Practice, and probably there could be some other further government information and guidance that is published. But ultimately, it's going to be for the tribunal to decide based on the facts of the particular case and when considered as a whole. So that's, I guess, the change in flexible working. And I think my other thoughts in that area is going back to the evidence. So if you're declining a request, having the evidence to back it up. So looking at the timesheets, the customer service levels, where there's peaks, where there's lows, demand and things like that, and being able to evidence it. Because as I said, that's all key information, relevant information that will help go on to ultimately lead you to making a decision for why you are to be declining. So again, we've got a poll slide, but I think I might just wait until the very end and run the poll. So apologies for that. Do bear with us. This next section of the webinar is really just talking through preparing the business for change. It's going to be really essential. And whilst the reforms are not going to be in force for some time, because they're so significant, they are the biggest reforms that employers will have seen in decades. It's really important to start thinking now. So I just want to take you through I guess, first of all, the implications of these reform bills. And I guess there's four sort of areas that I've thought about. So it will inevitably lead to increased absenteeism, an increase in the number of flexible working requests. Just the fact of giving employees that day one employment protection is going to lead to a higher absenteeism due to parental leave, paternity leave, etc. As I said, these are going to be the biggest reforms we'll have seen in decades. We'll likely get a lot of attention in the news, and so that's why we think there's going to be a lot more flexible working requests as well. And so with the increased absenteeism comes the greater admin burden being placed on you as the employer. So it could be the management time for responding to requests for the leave, the change to hours. Managers might need to seek external or internal employment advice, ensuring that legal compliance. Training for your managers, that's going to be absolutely fundamental. Things like maintaining accurate records, you'll need to have an effective record system in place. HR and payroll systems will need to be able to deal with the new rules, and just the administration that comes with managing the processes. And for flexible working, you'll need to obtain the evidence, like I've just spoken about a few moments ago, that have helped you to reach your decision, because without it, it's going to be difficult for you to show your decision was reasonable if you refuse. Then we need to consider the employment documentation, as this is going to be key to preventing risk of tribunal. But in the event that you are faced with a claim, having that robust documentation is going to be essential for defending. So you'll need to think about undertaking a review and update of your employment documents to ensure compliance. So that will be everything from your policies, your contracts of employment, your letters, templates letters. I mentioned the flexible working piece. The outcome letter is going to need to be really, really explicitly clear when you are declining a request, to make sure that you're effectively communicating a reasonable reason for your refusal. So that's going to be a massive piece as well for organisations. And then finally, increased costs. So with that additional absenteeism, with the admin side that comes with managing all the processes, reviewing and updating employment documentation, that's all going to have a direct impact on costs and budgets. So whether it's in connection with tribunal claims, whether there'll be that increase in the claims that you receive because perhaps refusing somebody's flexible working request. The legal test is more broader for employees, and so is the chance of them being able to successfully win a claim be greater. You've also got to think about if you're dealing with a dismissal and it's not been that long since the person's returned from a period of family leave. Obviously, they've got, or they will have, that avenue to get recourse through the tribunal system. It could be simply processes have been mismanaged. Maybe perhaps the managers haven't had that up-to-date training. Policies could be out of date, inadvertently, things like that that could lead to obviously situations being mismanaged. Training of your managers is key, but also don't forget your HR and payroll teams will also need that training. If you think about the reforms that we're going to be seeing, I think there's about 30 different reforms. They're significant, and there's some in particular that might be reforms in areas that are very complex, like trade union relations and things like that. And so it's really important that you train your own HR and payroll teams too. You may even have to adapt your current HR payroll systems to cope with the new rules. So again, it's the costs that come with associated with that. And then if you need any external support in reviewing your employment documentation, seeking advice, then obviously there's costs associated to it. So the planning is really key, and to start thinking sooner rather than later. And so I'm just going to take you through 10 areas that I think are going to be really pivotal for organisations in the coming weeks and months ahead. And I think the first thing to say is to stay informed and understand the reforms. Whilst the bill is still going through, it's very near to the end of the final stage of Parliament, and we're expecting actually to be passed as law around September. But it's important that you stay informed and understand the reforms, especially once it has been passed. We're going to get regulations drafted, circulated, ACAS codes, etc. Then it's important to actually carry out an impact assessment. So these reforms, it's not about just considering what you need to do to your existing people practices, but actually what wider implications will they have. So take, for example, I think SSP is probably an easy one to sort of illustrate. Now that's going to incur increased costs. You've got SSP being awarded from day one in theory, and you've also got low earners being eligible for it. But actually, as an organisation, what will that look like for you? How will you be able to deal with the additional costs, whether it's from SSP or from the additional costs that come with these family entitlements? Do you absorb them within your business, or do you pass those additional costs on through to the services that you offer and to your customers? So it's about thinking about the whole organisation from a sales and marketing perspective, from an IT systems perspective, your working practices, and obviously your workforce. So an impact assessment will be key, so you can really scrutinise the entire business to think about how each of the reforms will impact on them. Then there's the piece around budgeting and forecasting. So obviously, from what I've talked through today, there'll clearly be budget implications, whether it's because of the need for training, new systems, revising existing systems, additional costs with payments for statutory payments. So budgeting and forecasting is key. The next piece is around conducting a comprehensive audit. So we, for example, have online HR risk audit tools. It's actually really worthwhile regularly doing that as an exercise, but now is a good opportunity to do it. See how the land lies at the moment in your business and address any gaps that there may be. Hopefully there won't, but if there are, then it's about getting things in order now. And then, as I said, that's something that you can revisit moving forward, but understanding how your organization operates now is actually also an important aspect of planning for the reforms ahead. Strategic people planning is something that we always advise as an ongoing activity, looking at the year ahead, the next 2 to 3 years. How will you have to make sure that your business achieves success through your people? And it's about developing that strategic plan. So this is going to be really key for knowing what the reforms are coming up and mapping out what you need to do to comply, most importantly, but also still demonstrate that your employee value proposition, how you market yourself to and compete for talent, is still effective, because there is going to be that period of change. I've mentioned about HR and payroll systems. They're most likely going to need to be updated. If you've got perhaps a reliance on Excel spreadsheets, is now the time to consider moving towards HR and payroll systems, because of the additional rules and the significant changes that are coming about. Developing compliant policies and working practices will be key. Obviously, at the moment, we only know the headlines of the reform bills. We will get the detail when we get the regulations through. But nevertheless, you're going to need to have that compliant suite of documentation. And what's really important is engaging with your workforce, taking them along the journey with you and consult with them. And, you know, if you're unionised, making sure that your existing relations with the trade union are working for you and effective, and keep them informed as well as your plans. And then training your workforce. And as I said, it's not just training your line managers, but it's about training your employees and HR and payroll teams too. So there is a lot to think about, but these are the sort of the areas that we believe will be necessary in the coming weeks and months for organisations. Now, I said we've got some information just to share that you might find helpful. So, for example, to help with the budgeting and assessing how the reforms could impact your business, you might be interested in just watching a previous recording that we ran. We did a webinar about understanding the pay implications of the Employment Reforms Bill. It was just a few months ago. So do check that webinar out. There's a QR code. If you are a knowledge-based user, then obviously that will be in your webinar suite as well of previous recordings. But we did spend a lot of time thinking about the reforms and the pay implications, both direct and indirect cost implications. So do check that out. There's a QR code there. I mentioned a risk audit tool that we do offer. Again, so that's a free online tool that you can use. And as I said, it's really important to understand if your business is in a good state and position now. So understanding your current business will help you with planning for change and ensuring that you move in the right direction. It'll give you a sense to the extent to which you'll need to make changes to your policies and practices, if any. So the QR code there takes you to our online risk assessment. So we've got several on there, so do check those out. It should only take 10 minutes to complete the audit, and what you get back is a report, and it will tell you where there's the levels of risk within each of the areas. And it does cover the entire employment life cycle as well. And then finally, in terms of information, we've just launched the first set of impact assessment templates. So I think this is going to be a really significant and fundamental activity for all organisations. And as I said, it doesn't just relate to people practices. It's getting you to think about the reform and how it could impact your pricing strategy, your sales, your marketing, IT and systems, the whole spectrum of running an organisation. So we've created some tools here where it basically gets you through questioning all aspects of the business and helping you to map out perhaps where there are strengths, weaknesses, obviously opportunities, and essentially understand what actions you may need to introduce to mitigate any risks that could come about because of the reforms. So currently we've just launched ones that relate to fire and rehire, flexible working, harassment, the SSP reforms. That's a particularly big one, particularly from a cost. 0-hour reforms, and those of you that operate in the industry, hospitality, etc. There's also one for tips and gratuities, and of course tribunal time limits, because if you didn't know, tribunal time limits are going to be increased from 3 months to 6 months, and that opens a whole can of worms as well. So do check those out. We've just launched the first set, and we're currently working through the other reforms to create impact assessments for those too. So before we get on to taking your questions, I just wanted to put some context around what we've spoken today and some timescales. And I think there is some good news. It might seem doom and gloom when we've talked about these reforms in previous webinars, just because of the number of reforms that we're seeing, but also the scale and the size of the reforms and the significant implications. But the good news is that the government have published this week, or the end of last week, its roadmap in how it intends to implement these, and it includes timings. And the good news is that it's pushed back slightly, so it gives us that little bit extra time to prepare. So I'm just going to share with you timescales relevant to what we've discussed today. And let's just get the images up. So what we'll see, as I said, these are just for the family-friendly rights and flexible working. So from the autumn, we're going to see some public consultation open. So a lot of the reforms will need public consultations taking place. The ones in the autumn will be about the bereavement leave and the rights of pregnant workers. Then the next key milestone is the winter of this year, early next year. And again, there's a further consultation, and that's where the flexible working changes will be open for being commented on and considered. But actually, when it comes to implementation of the reforms themselves, we know in April next year, there will be other things in this, by the way, but these are just the family-friendly ones. We're going to see the paternity and parental leave changes come into force. So that'll be everybody for entitled from day one of employment, and for those with for paternity leave, they'll be able to take it either before or after shared parental leave. So that's the first milestone in terms of reform coming into force. And then 2027, so this has really shifted back some time. They are indicating that the bereavement leave will come into force. But remember, we've already got the parental bereavement leave. That's still running now. But when it broadens, that'll be 2027. And the rule changes for flexible working and the rights for pregnant workers. So I think, as I said, there was a bit of good news in terms of things are being pushed back. You're going to probably hear or read a lot in the news over the next few months about consultations. We tend to get involved in consultation processes. We submit our input, and in the hope that we can influence policy in some way. But yeah, so there'll be a lot of regular consultations taking place, because it's not just about these, it's all the other 25 odd reforms as well. In terms of the bill itself, I mentioned earlier on the webinar, it is at the final stages in the House of Lords. At the report stage, it needs to go back for consideration of the amendments back in the House of Commons. But once it's done that, then it will be passed over to be given royal assent. But Parliament goes into recess on the 23rd of July, I think. So it's whether or not those steps can be carried out and completed in just a couple of weeks, which is unlikely, which is why I was saying earlier it's probably going to be around September time that the actual bill is actually a piece of law, but there will be staggered implementation dates. And then just on latest developments, which I think is really important. So as of today, like I just mentioned, it could be given that royal assent from around September, i.e. becomes that act of law. We have a full list of amendments that have been published. What the pattern has tended to be throughout the whole process is the ones put forward and tabled by the government are the ones that tend to get accepted. the new government, there's a new government publication called the Implementing the Employment Rights Bill, Our Roadmap for Delivering Change. That was what gave us the information around the timeframes. And then just this week, it's been announced that there will be a full review into the UK's parental leave and pay, but it's not just going to cover parental leave, it'll cover all aspects of family entitlements, so your adoption, maternity, etc. So we'll see how that goes, what further developments there could be. I suspect and perhaps hope that there will be some developments in the area of shared parental leave, because it's a bit of a headache, shall we say. So yeah, so that's just been announced this week. And I just wanted to flag that there's a notable absence from the Employment Rights Bill, but we know as a party in the manifesto, the Labour Party were keen for having a right to disconnect. I think they are still keen on bringing something in around the right to disconnect. It wasn't put into the Employment Rights Bill, but we understand that it could still be introduced, but in the form of a new statutory code of practice, which will obviously need that public consultation. But I guess doing this is actually following suit with a lot of countries in Europe, actually. Ireland, for example, have already introduced a code of practice for the right to disconnect. So I think it's going to be more likely something does come into force at some point. So Sue, I don't know whether we take questions now or whether we run a few polls if we have any.
So we'll leave the polls for now. There
Okay.
have been some technical difficulties. They just won't load, unfortunately. So,
Okay.
but I have got some questions, so no worries about that. So there's a few questions around the same thing. Will the changes be apply in Northern Ireland? And I think if I'm right, it's the same as normal, and that they will eventually, but not in the same timescales as the rest.
Yeah, I think.
Okay. Yeah.
Okay. Oh, I can't remember off the top of my head. There could be some that will, but there'll be some that won't. I think. But if there aren't, if they're not covered at this point, there will be at some point. What I'll need to do is just get run through all the reforms and have a look. But yeah,
So we
it
can
depends on
clarify.
the
We'll come
reform
back
is.
and clarify. Yeah, we will come back to you and clarify around Northern Ireland. You asked the question about, is the risk assessment suited to Northern Ireland? I would think the risk assessment's fairly generic, so it would be. It's just that the timescales for implementation, you may have different ones for some of the aspects. So so you may have a bit longer, or you may not. So once we clarify the timescales for you, whether you're on the same timescales as everybody else or whether it will follow in due course, we will find out. But I would say yes, you potentially have a bit more time, but doing the risk assessments, understanding if there's anything you can implement now that is prepare yourselves for it, because there's no problem in enhancing processes and that are going to align with it, so you have less of a challenge when it comes to
That's a
the
good
law
idea.
changing. So I think it'd be good to understand where you sit anyway, and then plan accordingly. Hope that helps anyway. So I'm sorry we couldn't be totally sure. It's normally with legislation, the Northern Ireland follows about a year later, but they don't adopt everything. Such as the discrimination laws are different in Northern Ireland, so, and one or two others. So, and you've still got some slight differences in the disciplinary codes. So, so that's why we'd recommend, you know, doing the audit, and we will clarify the timescales if we know any.
Which reform is coming in when, or which area, yeah.
So the other question is an interesting one. It's around pregnancy, maternity, and one of the questions was around, you know, do you have to offer a role to a pregnant returning worker even if someone else is better qualified or suited?
Yes.
And how does that differ from positive discrimination? And what if you've got more than one pregnant employee but only one role available?
Basically, it's been yes, they get priority in short, and it's whilst the law changed, there's always been some protection for people on maternity leave to get that extra protection, and I think it just must stem back to the fact that there's always been, or there's, I guess, the discrimination element of it, and so I suppose naturally they're given that extra protection. But
Yeah.
Yeah, who knows why, other than they're more likely to be discriminated against than somebody that's not. So they've always had that protection. If you've got two pregnant individuals, but with one role, then, so I don't know what you think, but it's about having that fair selection process to narrow it down.
Yeah, well, they're on an even playing field on the one aspect, so then you have to find a fair and objective way of distinguishing the best person. You could use the best person on skills in that scenario, because there's no other priority. They've both got priority over anybody else. But and so if you had 3 people, 2 of whom are pregnant, then you'd prioritize the 2 who are pregnant, and you'd take the one who got the best skills out of those 2.
And what I would always suggest is you have the selection assessment looked at by another senior leader. So to almost sense check that that they're comfortable that a fair assessment has taken place, nothing's being missed, and things like that. Moderation, get it moderated.
Yeah. Thank you. So then we've got a question about part-time requests. Somebody requesting part-time and to have flexible hours as well. Can you agree to part-time and not flexible? Absolutely. So I think all about flexible working applications, isn't it? It's about understanding what they ultimately want to achieve, what you as a business can accommodate, and how you can marry the 2 together. And sometimes it needs compromises on both sides. So if you can justify from a business perspective, you can agree to part-time hours, but for good reason you need them to be fixed part-time hours, or with some flexibility but not the full flexibility they're looking for, then that's something you can agree potentially. Would you think?
Yeah, flexible working, even though it suggests there could be some flexibility in the hours of how they work, it could be a request for Monday to Wednesday 9 till 3, so they're set hours, set days, but yeah, definitely part-time.
And then a question around, can individuals apply to work flexibly around the affordability of coming into the office?
Wow,
that's an interesting one.
Well, I think an organisation needs to know the stability. I suppose it depends on the context you operate, but you need that stability, don't you? You need to be able to resource plan work, etc. And I don't. Ultimately, the business needs must come first.
Yeah, and also, what are other staff doing? You know, you don't set precedents that you couldn't accommodate. You know, it's a bit. It's not necessarily objective, is it? If you're not careful with that. So I think it's one that would have to be handled very carefully.
I would say offer things, whether the job could be something that's worked remotely, that as an alternative or compromise or balance between coming in and working from home.
Yeah, whether there is, again, the compromise, isn't it? Or if the job role can only be done in the office, then the justifications there will prevail. But if it's a nice to have, then it's slightly harder to enforce. But it depends on what you do with other staff, because you have to be fair to everyone. So if you said that to everyone, if you agreed that, and then you'd have everybody saying, well, I can't afford it either, then you'd have nobody in the office. So actually,
it's got to,
it's a wider question, isn't it?
The business needs to drive it. Of course, you need to consider the person's circumstances and the reasons for wanting it. But and of course, if there was something of a protected characteristic nature, then you'd have to be thorough in your examination of the request and really try and exhaust all other avenues. But if other than that, it's, you know, ultimately you've got to operate your business and ensure you've got enough resource in place.
Yeah, absolutely. There's some clarification required around the shared parental leave. Can you start it if the mother's still on maternity leave? No, because you relinquish your maternity leave.
Yeah.
But you can only do claim one type of leave at the same time, can't you? I think so.
At a time, yeah.
Yeah. And somebody's asking for some more information about the shared parental leave and paternity changes. I think we'll be issuing some guidance anyway through knowledge base. We'll be updating all the articles and everything else about that we already have on shared parental leave and paternity changes.
I think we've got on the knowledge base, there is an article and there's lots of information about the Employment Rights Bill, and on our main website we do share a lot of content as well, and I think there'll be something there about the changes as well that are coming through.
And then you've got somebody making a flexible working request while on maternity leave ahead of their return, but it's a significant reduction in hours. Do you have to agree with it because of the protected characteristic of maternity leave? It's a common one though, isn't it?
Yeah. So when you're dealing with flexible working requests and it's connected to a protected characteristic, so it might be, you know, for health reasons, i.e. disability, protected characteristic, or family leave, there's no automatic right for anybody. What you would want to do as an employer is make sure you exhaust all avenues, look at all options for how and whether it can be accommodated, what compromises, if it can't be accommodated, before ultimately responding. And if you can't in any way, then obviously you've got those statutory reasons that would form your reason for declining it. You just want to make sure that you've been really thorough in your investigations into whether it could be accommodated. And I always say, start off in your thought process that it can be done, and then work backwards, and then through working backwards, you'll identify and pull out challenges that may come up, and therefore how will you overcome that challenge, as opposed to entering a process and thinking, oh, I'm sure it's not going to be accommodated, I'm sure we can't do it. That's going in with that negative mindset. You need to go in assuming you can, and then work out what challenges could come up, how can you overcome them. If you can, great. If not, then that's all part of your thought process in leading you to a decision where you can't accommodate. But nobody has the automatic right to flexible working requests.
Yeah. And I think it's similar to the next question, which was they already allow all staff to work from home 50% of the time. Somebody going on maternity leave has said they might come back part-time, but wants to only work from home. She says, are we being flexible enough in that we offer 50%? And also, can we say you must have childcare in place when working? Absolutely, to that last point. You are the contract is to work for your employer. You can stipulate in the contract the requirements of that, and you can absolutely state that if they're working from home, then childcare must be in place. Appropriate childcare must be in place in a different room to which in which you're working as well in the house, so that it's very clear that you are working, and that is your 100% commitment when you're working from home. So yes, and again, it's the same rules for the flexibility. If they want to work from home permanently, then that's against the policy of 50%. So you would have to consider, is that something? Why do they want to work from home? It can't be for childcare because that's not the principle of the 50% working from home. Is to work from home, not to do childcare as well. So you need to just consider that carefully under the usual rules.
Also, yeah, I think rather than working completely at home, which won't be in line with your policy, what is 50% of their time? So if they're coming back 4 days, then could it be that those 2 days are worked from home? So they are still falling in scope with the policy. So you're not indirectly, disproportionately excluding them, but it comes back to the role and whether it is something that can be worked from home and in those 2 days.
Yeah, absolutely. I think, I don't know, how are we for time? I think there are a few more questions. Do you want any more? Or so we should move on to so somebody performance managed due to capabilities and was facing possible dismissal, then goes on maternity leave without it being resolved. At the same time, the business are looking at redundancies.
Oh my goodness.
Is the pregnant employee exempt, and would it be automatic unfair dismissal if they were made redundant?
So what we know of the reforms is that the rules that we have for redundancy dismissals will be extended to all forms of dismissal. So if you are picking up capability issues, well, clearly capability dismissals are one of the fair reasons to dismiss. So it sounds like what it will mean for employers is there'll be some extra steps and processes that that will need to be given to people that fall into that category, and some priority. So like, you know, with capability, you do always should be looking at other roles to avoid dismissal, should be that last course of action. Well, clearly you would give somebody who was just returning from maternity leave that alternative position. So it's but we don't have the detail, so it's a little bit hard, but the principle of having extra protection because you've just come back will apply, and a dismissal because of having just come back will be unfair. We don't know enough detail.
No,
unfortunately.
Absolutely. Okay, thank you. So going back to flexible working again, I think it's the topic of the day. So a couple of links. So so it's how do you if one, say, property manager's part-time, do they all have to be offered that option as it's the same role? And linked with, if you approve a flexible working request, but if 5 more people request it, it will no longer be feasible. So can you say to that original request, yes, we can do it, but if any more request it, then we will have to stop it. But you have to treat each one, don't you, on its own merit. The first request in is in the circumstances then. The second request in is based on the circumstances, including anything you've agreed flexibly with any other member of the team. So that might affect the fact that you can't now offer any more. So the first person will, you know, you consider each case separately. So if all 5 people in a team request part-time at the same time, then you have to consider whether you can accommodate that, which is a complete rethink potentially. But you still have to treat each case individually, and you would look at them in order that they came in. If you could only do it for 1 and not 5, then you'd look at the first one, treat them in isolation. Yes, you could do it if all the other 4 were full-time. Then the second one, can you do it with 1 person or 2 people part-time and 3 full-time? And that, unfortunately, would be how you do it, but that would be a fair way of treating them all, I think. Would you?
Yeah, I would. And it's quite common to have in your flexible working policy just a brief statement that says, you know, where flexible working applications are accepted, it's not an indication of future ones also being, basically it's not a precedent for future requests of the same nature, because it all depends on your business circumstances at each point in time, like Sue says. So yeah, just go back and have a look at your flexi policy. If you haven't got that in, make sure you've got it in.
So yeah, I think that's probably as many as we can do now. If there are any other ones that we haven't got to yet, then we can follow up with you directly. We'll come back and clarify the Northern Ireland aspect. And yeah, I think that's that's all the questions.
Brilliant. Okay, I was going to suggest for the next slide, poll slide, Sue, that perhaps responses in the comments box.
Yes, exactly. Just load the slide. That's fine.
Perfect. So, so what we'd like you to do, so this would be a poll. So would like to know what further support or information you'd like to receive from us regarding obviously what we've discussed today. So would it be perhaps project support, HR advice and support on managing the changes that we've gone through, training even, our payroll services, or even our policies, handbooks and contracts documentation. So let us know in the question panel what you're keen to find out about our support on, and then we can get in contact with
follow
you.
up. The other thing, the next slide, Victoria, if you want to load that one, you can also contact us direct. So these are some of the means you can contact us. So you can add your questions, or if you want us to contact you in the questions panel, or you can email Victoria on v.templeton@hrsolutions-uk.com, and then we will get in touch with you. And if there's any follow-up that you want us to help you with, but yeah, we've got a lot of tools, a lot of things we are building and constantly updating as we get more and more information released. So we will keep you informed as much as we can. Let us know if you want to be added to the newsletter list. If you want to know where everything is, we will send you for registering. We will send you a link to the on-demand recording and also to a copy of the slides as well.
Yeah.
So, thank
Brilliant.
you.
Thank you. And then just really in terms of our webinar schedule, because we're dealing with the reforms really pretty much most of the year now. So next month we're going to be looking at the importance of the probation periods and how they may change in the future. And they are going to be changing with obviously the unfair dismissal rule coming in from a day one right. September we're going to look at primary areas of discrimination, and then in October we're looking back at the new deal for working people again and looking at how we can protect the business from tribunals. November is going to be thinking about budget implications on HR management, not just from a reform bill perspective, but just obviously we'll have had the budget and just sort of have a think about how it may impact our workforce. And then December is all about the new deal for working people and how we can plan for change. Next year is the start of rolling out the new legislation, new reforms, so it's how we can work on doing that. And then obviously we're going to be thinking over the next few weeks our webinar schedule going into 2026. Can't believe that. So if you've got any ideas what you'd like us to cover, please do let us know and we'll take a look through and we'll build those into our webinar schedule as best we can. So do let us know on that. And then just finally, I've mentioned the HR knowledge base actually throughout the session. It's our online tool that basically allows you access to all of our template documents, policies. We've got a wealth of articles covering the entire employment life cycle. Some of you on the webinar today will be members of it. So do scan that to find out more, the QR code there that's showing, and do check that out. And then we're offering a free 30-minute consultation with one of our experienced HR advisors. So you might have a performance issue, you might have some absence challenges you need to work through. Give us a call, check us out and see how we can help you in that free 30-minute consultation. And then that brings me to a close. So I want to thank you for attending today. Apologise for the polls. Don't know what happened with the technical side of that, unfortunately, but I really appreciate you all taking your time out of your busy schedule. And thank you to Sue as well for supporting with the running of the webinar. And we hope to see you next month. Thank you, everybody.
Thank you.